Good afternoon. Thank you for joining part 2 of navigating the interactions between workers' comp and the ADA. We'll kind of pick up where we left off last time. So if you didn't join us the first time, this may be a bit confusing and you may be able to get some knowledge from watching that first webinar. So if you missed us last time, don't be worried if you are feeling a little bit behind here. But just as a quick recap, we have part 1 where we discussed occupational injury and disability as defined terms and disability related questions and medical exams, as well as hiring of those with a history of occupational injury. So part 2 is going to focus on the return to work aspect and the application of the direct threat standard, reasonable accommodations that are related to those with disability related occupational injuries, and then finally light duty issues and exclusive remedy provisions with workers' compensation laws. Of course, you have me as a reference and counsel regarding particularized instances. So this really is to sort of set background knowledge as to the working nature and sort of relationship between workers' comp and ADA, because those are regular questions I get asked about. But as always, you're welcome to reach out. Of course, any presentation can't be provided without a disclaimer. So I just want to remind you that things are changing and evolving. So although the hypotheticals we'll cover in this webinar may have a certain answer, even the slightest change to your particularized situation from the hypotheticals you see here in this webinar can change the outcome. So again, please reach out to me when you have particularized questions. We'll start with return to work decisions and application of the direct threat standard. Let's first start with a question and answer. We're going to have that throughout, especially the second part, because I'm not trying to create a theoretical sort of nature of discussion about what all these legal terms mean, but I think that just the application of questions and answers will help best. So first, a very routine question I get, may we require an employee with a disability-related occupational injury return to work with a full duty release, essentially? You know, and the argument often is that we need them to be fully ready for work. They're getting fully paid, so we want to require a full release. The answer to that is no. The term full duty may include marginal as well as essential job functions, or may mean performing job functions without accommodation. An employer, you know, may not require that an employee with a disability-related occupational injury who can perform those essential functions be able to return to full duty if, because of the disability, that person's unable to perform these marginal functions. And it wouldn't impose an undue hardship on the employer, you know, so hence we see light duty releases and things like that. So simply put, we don't want a blanket standard and practice within the workplace of requiring, you know, full releases, even though they're getting, you know, arguably their full pay and benefits. May an employer refuse to return to work an employee with a disability-related occupational injury simply because it assumes, maybe correctly or incorrectly, that he or she poses some increased risk of re-injury and increased workers' comp costs? I get this question a lot. You know, we see sometimes a pattern of injuries from a particular employee. Sometimes we believe it's intentional, other times we just think it's a matter of happenstance. And often the question comes up, can we, do we have to reinstate them, essentially? Do we, or can we refuse the return to work because we just think that they're a high risk? Generally, the answer is no. You know, we need to return them unless we can show that the employment of the person in this particular position poses what is a direct threat, and more on direct threat will come here in a moment. But likely other webinars we've provided here at TPM, you probably know a lot about that. But where an employer refuses to return an employee to work because it assumes that his or her disability-related occupational injury creates, you know, an increased risk of more injury, you know, and thus increased comp costs to the employer, it really is discriminating on the basis of a disability. Because remember, we started this hypothetical with disability-related occupational injury. So the employer, is to not refuse to return to work an employee who's able to perform the essential functions of the job with or without a reasonable accommodation, unless we can show that returning that person to the position poses a direct threat. So we'll hear these words come up a lot, and you're likely already familiar with them. So if you have, what is a direct threat and what constitutes a reasonable accommodation, we'll actually have webinars on all of that. So sort of just, come with us along this journey in the next 20 minutes and take note as much as you can. And the further the question goes on specific terms, you're welcome to reach out to me. The fact that an employee, has a disability-related occupational injury does not by itself indicate that he's unable to perform the essential functions of the job, or that returning him to the job is going to pose a direct threat. So we have to do away with those general presumptions. Sometimes it could, but as a matter of a rule that we apply, it does not. In some circumstances, evidence about an employee's disability-related occupational injury may be relevant to whether he can perform the essential functions of the job, but it may be relevant to the direct threat analysis, but it's not going to just conclude the matter dispositively each and every time. So let's take an example. We have an employee who's a typist, and she breaks her wrist while trying to move heavy equipment with a coworker. And this employee is unable to work for 6 weeks and receives workers' comp. And after the wrist completely heals, she's asked to return to work, and the physician indicates that there's little risk that the repetitive motion, of typing will further damage the wrist because she has completely healed. Yet the employer refuses to return her to her position because the employer believes that the repetitive motion will cause serious and permanent re-injury of her wrist. And understandably so. I mean, it sort of makes sense. Like, you hurt your wrist typing, and now you supposedly have recovered fully, but we think putting you back in that exact motion is going to re-injure it, and we don't want to do it. This sort of situation comes up a lot, and then the question arises on the employer's side: must we return her to work, or what? We actually already refused to return to work. What do you think about that? And here's what I think. The evidence here supports that the employee does not pose a significant risk of substantial harm, which is, a direct threat. Her injury was not caused by repetitive motion, as the facts state. There was no indication to give to that. Her wrist has completely healed, as the physician said, and there's little risk that she would re-injure her wrist through repetitive motion. So relying on what the medical provider's note has stated, we don't have a lot to go off of, for refusing to return her. And in this situation, I think the employer would have violated the ADA by not returning this typist to her position. So let's take up example B. Here we have an employee who's a maintenance worker that badly fractures both ankles in a workplace accident, and she's unable to work for 6 months and receives workers' comp. Her ankles do partially heal, but she's unable to walk and stand for more than short periods of time. And this maintenance job that she has requires extensive walking and standing on cement floors. Her medical exams and report shows that there's a high probability of immediate, severe, and permanent damage to this employee's ankles if she walks or stands for more than short periods of time, and especially on hard surfaces. Remember, she's primarily standing on cement in her position. So assume that there is no accommodation that will lower this risk of harm. So the question here: can the employer refuse? Here the employer may refuse to return the employee to the maintenance position because there is sufficient evidence to support a finding that the employment position poses a direct threat, which is again a significant risk of substantial harm that cannot be eliminated or reduced through a reasonable accommodation. However, we're probably going to be obligated on the employer side to reassign the employee absent undue hardship. So although although we may not have a reasonable accommodation here, we may need to reassign to a different position. So definitely don't, make the tangible employment decision of termination or an expression of no right to return to work, in these sorts of ambiguous situations, without seeking counsel. It's always best to do that first before we make that decision. Here's another question for you. May an employer refuse to return to work an employee with a disability-related occupational injury simply because of a workers' compensation determination that she has a permanent disability or is totally disabled? No, the workers' compensation laws are different in purpose from the ADA and may utilize different standards for evaluating whether an individual has a disability or whether he or she is capable of working. So, for example, under workers' compensation statutes, often a person, say that loses vision in both eyes or has loss of use of both arms or legs, may have a permanent total disability, although he or she may be able to work. A workers' compensation determination also may relate to a different time period, such as determination and that sort of determination. So like different time periods and things like that, will not be dispositive regarding an individual's ability to return to work. Although it may be relevant, in providing some evidence regarding an employee's ability to perform the essential functions, it's not going to be dispositive. So don't be, conclusive on the matter. Under the ADA, is a rehabilitation counselor, physician, or other specialist responsible for deciding whether an employee with a disability-related occupational injury is ready to return to work? No, the employer bears the ultimate responsibility for deciding whether an employee with a disability-related occupational injury is ready to return to work. So the employer, rather than the counselor, physician, or specialist, must determine whether the employee can perform the essential functions of the job with or without reasonable accommodation, or can work without posing that direct threat that we talked about. And just for reference to these questions in mostly complete form, I've taken from actual questions that you all have submitted or asked over the past quarter. So hopefully, if you're listening and you're seeing that one of these is your question, it just very well could be. So on that previous note, though, regarding who's responsible for determining basically, really whether someone can return to work under the ADA, and assessing the essential functions of the job with or without reasonable accommodation within the workplace, or the potential of that person posing a direct threat. The employer bears the ultimate responsibility. It doesn't mean that we disregard what the healthcare provider has noted, but we ultimately bear the ultimate responsibility for that. But we will find it relevant and helpful to seek information, from the healthcare provider. So we get that sometimes from the note that's provided, the medical note, just so about the specific functional limitations and abilities. And sometimes medical notes, provide possible reasonable accommodations suggestions. Not that we always have to follow those, but sometimes they're just wholly irrelevant and not helpful, and other times they can be insightful, or at least we can find something comparable, to do for that employee. So in order to obtain useful and accurate information from that medical provider, we might, seek out specific information about potentially the following. So the essential functions of the employee's position and the nature of the work to be performed. So we may be providing this medical provider with what the essential functions are, so they better understand the job. I know that a lot of medical providers don't know what some of these positions really are doing and what's required by them. So for them to be able to determine whether a full release is a functional thing for that employee at that time, they're going to have to know more about the job. So providing them, some essential functions list, and what type of work environment and operations are inherent to this position, as well as possible reasonable accommodations. An employer may obtain useful information from others who are not experts, but who are knowledgeable about the employee's current abilities, limitations, and possible reasonable accommodations. To tell you the truth, it doesn't seem like we ever usually get that far. Usually we get the medical note. If the medical note doesn't seem to really comprehend the person's position, then we may, send more information to that medical provider, and then see if that medical note gets amended. And then for others, some of you have working sorts of relationships, with the medical facility. They have some of your stuff, your positions on file, and I think they reference that. Those medical providers reference those, routinely, especially for those of you that operate in smaller communities. Let's go to part 5 here, reasonable accommodation for persons with disability-related occupational injuries. So accommodations for those that have disability-related occupational injuries. Does the ADA require an employer to provide reasonable accommodation for an employee with an occupational injury who does not have a disability as defined by the ADA? No, the ADA does not require an employer to provide reasonable accommodation in this instance. May an employer discharge an employee who is temporarily unable to work because of a disability-related occupational injury? No, and I think that sometimes we jump the gun a little bit in saying, well, we're not finding use of this employee or these employees because they're of a disability-related occupational injury, and they're probably not going to, even maybe at least 6 months they're going to be out. Like, can we just discharge them? And generally the general answer is going to be no. We leave them on the books, and we make that employment-related decision later once more information comes about. What are the reinstatement rights of an employee with a disability-related occupational injury? Well, an employee with a disability-related occupational injury is entitled to return to his or her same position unless the employer demonstrates that holding open the position would impose an undue hardship. And in some instances, an employee may request more leave even after the employer has communicated that it would impose an undue hardship to hold open that position. And in this situation, the employer really has to consider whether it has a vacant or equivalent position for which the employee is qualified, and to which the employee can be assigned. Now, if there is an undue hardship, then with that reassignment, and we've talked about what constitutes an undue hardship in other webinars, then our conclusion might be different. Maybe we can't. But for example, let's say that an employee needs 6 months to recover from a disability-related occupational injury, but holding that person's position open for more than 4 months is going to impose an undue hardship. Then we're going to have to consider whether it has, whether we as the employer have a vacant equivalent position to which the employee can be reassigned for those remaining 2 months that we're saying would cause an undue hardship. So if an equivalent position is not available, then we'll look for a vacant position at a lower level, but not until we've already looked for an equivalent position, on an equal level. And then once we've determined there is none available, we can then look, is there a vacant position at a lower level available? Continued leave is not required as a reasonable accommodation if a vacant position at a lower level is also unavailable. So if we then reach the end and say, well, there's also not one available at a lower level, well, then we've likely come to the place where this continued leave is not going to be required as reasonable accommodation. So that's sort of the evolution of things. But we definitely don't just jump from we can't hold this position open, and so we're going to fire him. There's more steps to it that we have to consider. Next question: must an employer, as a reasonable accommodation, reallocate job duties of an employee with a disability-related occupational injury? Yes, if the duties to be reallocated are marginal functions of the position that the employee cannot perform because of the disability. So let's keep in mind, what reasonable accommodations are. It includes restructuring sometimes of a position, which is sometimes the reallocation or redistribution of marginal functions that the employee cannot perform because of the disability. But we're never required, to eliminate the essential functions of the position. So next question, may an employer unilaterally reassign an employee with a disability-related occupational injury to a different position instead of first trying to accommodate the employee in the first position that they held at the time of the injury? So this is, the employer says, well, this person was out and we had to hire John, to fill the position because Dave was out, and so we're just going to reassign him. That's right. That's all right, right? No, the employer needs to first assess whether the employee can perform the essential functions of the original position, and whether the employee can do that with or without a reasonable accommodation. And some examples of reasonable accommodation, we'll do a quick reminder, include job restructuring, modification of equipment, maybe a part-time schedule. Reassignment should be considered only when accommodation within the employee's original position is not possible, or when it would impose an undue hardship. So simply put, reassignment should be considered only when an accommodation within the employee's original position is not possible or would impose an undue hardship. And before we jump to say, well, this is an undue hardship on us, we have to remind ourselves that undue hardship has its own test to it. So we don't want to be quick to just say it's unduly hard on us. We do have to go through the analysis of that. Next question, must an employer reassign an employee who is no longer able to perform the essential functions of the position, even with a reasonable accommodation, because of a disability-related occupational injury? So I'll read that once more. Must an employer reassign an employee who is no longer able to perform those essential functions of their original position, with or without a reasonable accommodation, because of a disability-related occupational injury? The general answer is yes, where an employee can no longer perform the essential functions of the original position with or without a reasonable accommodation. That's all attributable to this occupational injury. An employer needs to reassign that employee to an equivalent vacant position for which he's qualified, absent undue hardship. So if no equivalent vacant position, in terms of pay and status and all that exists, then the employee must be reassigned, like we talked about just a couple slides ago, to a lower graded position for which he's qualified, unless that would cause an undue hardship, and obviously unless there is no vacancy available. And then at that point, we make our decision, to not reassign. So what about if there is no vacancy for an employee who can no longer perform the original position because of a disability-related occupational injury? Must the employer then create some new position or bump another employee, from their position so that this disability-related occupational injury employee can come in and take that position? No. The ADA does not require an employer to create a new position or bump somebody else from their position in order to reassign an employee. So we're not asking you to bump off the good working employee that's in some other position, get rid of them so that this, this disability-related occupational injury employee can take their position. That's not a requirement. When an employee requests leave as a reasonable accommodation under the ADA because of disability-related occupational injury, may an employer provide an accommodation that requires him or her to remain on the job instead? Yeah, an employer, need not provide an employee's preferred accommodation as long as the employer provides an effective one. And effective accommodations are sufficient to meet the employee's job-related needs. So an employer, may provide an accommodation that requires an employee to remain on the job in lieu of providing leave, like reallocating marginal functions or providing temporary reassignments. The employer is obligated, however, to restore the employee's full duties or to return the employee to his original position once fully recovered, or I should say, once recovered sufficiently to perform the essential functions. So not always fully recovered, right? But at least recovered sufficiently to perform the essential functions with or without a reasonable accommodation. But if an employee with a disability-related occupational injury does not request a reasonable accommodation, but say simply request leave that's routinely granted to employees, an employer may not require that he remain on the job with some type of adjustment unless it also requires that of employees without those disabilities. So there we're kind of hinting back at, let's make sure there's, equal treatment. We're not making it harder on the person with that disability related occupational injury. When we'd allow, somebody without that history to take their accrued leave, or whatever permitted, routinely granted thing that we have going on for the employees. And next question, and we're moving at a fast pace here because I'm respectful of your time, and I want to make sure we finish, within, we try and keep it a half hour, so I have just a couple minutes left here. May an employer satisfy its ADA obligation to provide reasonable accommodation for an employee with a disability-related occupational injury by placing him or her in a workers' compensation vocational rehabilitation program? This question, I sort of worded it, reworded some of these, but essentially this was like one of your questions. So do we satisfy ADA obligations to provide reasonable accommodations for an employee with a disability-related occupational injury by placing that person, in a rehab program of some sort? No, generally. An employer cannot substitute vocational rehabilitation services in place of a reasonable accommodation required by the ADA for an employee with a disability-related occupational injury. An employee's rights under the ADA are separate from the entitlements under workers' comp law. So we kind of usually keep those, we try to keep a separate analysis of that. Now, the ADA requires employers to accommodate an employee in his or her current position, sometimes through job restructuring or some other modification, absent undue hardship. If it would impose an undue hardship to accommodate an employee in the current position, then the ADA requires that an employer reassign the employee to a vacant position in which that employee can perform, again, unless that causes undue hardship on the employer. May an employer make a workplace modification that is not a required form of reasonable accommodation under the ADA in order to offset workers' comp costs? Nothing in the ADA, prohibits an employer from making workplace modifications that are not required, that are not a required form of reasonable accommodation under the ADA. For example, so the ADA does not require employers to, lower your production standards, to accommodate individuals with disabilities. However, an employer is clearly permitted to lower production standards for an occupational injured employee as a way of returning him or her to work more quickly. So you can kind of see how that line can be drawn. And finally, let's end with light duty issues and exclusive remedy provisions in workers' compensation laws. The term light duty has a number of different meanings in the employment setting. Generally, light duty refers to a temporary or permanent work that is physically or mentally less demanding than normal job duties. So, it may be temporary or permanent work, but a little bit less than what the job duties were before. Some employers use the term light duty to mean simply excusing an employee from performing job functions that he's unable to perform because of the impairment. Light duty may also consist of particular positions with duties that are less physically or mentally demanding. And additionally, an employer may refer to any position as sedentary or as less physically or mentally demanding as light duty. So I say light duty, many times, and we get light duty as coming through on the medical docs, and then the managers are talking about light duty, and sometimes they're all in different contexts. So that's why I wanted to just briefly touch on light duty and sort of how it can sort of mean the same thing, but in different ways, or perhaps just entirely meaning different things depending on the setting. In the following questions and answers, we're gonna say the light duty term refers only to particular positions created specifically for the purpose of providing work for employees who are unable to perform some or all of their normal duties. So this is when we've created a particular work duty list for a person that is coming back to work on light duty, and it's not exactly as it were before when before the injury. It's a little bit modified. So with that understanding, let's go to this question. Does the ADA prohibit an employer from creating a light duty position for an employee when she is injured on the job? No, in most instances, an employer may recognize a special obligation arising out of the employment relationship to create a light duty position for an employee that's been injured while performing work, and as a consequence is unable to perform those regular job duties. That type of policy on its face does not treat an individual with a disability less favorably than an individual without a disability, and it also does not screen out an individual on the basis of disability. And those are things that we're always, wary of. We don't want to be doing that. I mean, of course, an employer must apply its policy of creating a light duty position for an employee when he's occupationally injured on a non-discriminatory basis. So in other words, an employer may not use disability as a reason to refuse to create a light duty position when an employee is occupationally injured, but I think that goes without saying. An employer, need not create a light duty position for someone that's not been occupationally injured. The principle that the ADA does not require employers to create positions as a form of reasonable accommodation applies equally to creation of light duty positions. So just as we said, we don't have to, bump someone off from their job to create a position for John who got injured. The same sort of applies with this whole arena of the creation of light duty positions. But we must provide other forms of reasonable accommodation required under the ADA. So for example, again, subject to undue hardship, an employer must be willing to, look at restructuring a position, by redistributing marginal functions of the position of which the employee can no longer handle because of the disability. We might need to look at modified scheduling, part-time work, or maybe, someone with a particular medical condition, afternoons are going to be better for them, or mornings. We also look at reassigning a non-occupationally injured employee with a disability to an equivalent existing vacancy for which he's qualified. An employer may not avoid its obligation to accommodate an individual with a disability simply by asserting that the disability did not derive from an occupational injury. But we will look at these options, but we're not just generally obligated to create a new position or create wholly or in part of the light duty. We would look at these other forms of accommodations first. In some cases, the only effective reasonable accommodation for an individual with a disability may be similar or equivalent to a light duty position. So the employer would have to provide that reasonable accommodation unless the employer can demonstrate doing so would impose an undue hardship. So let's say that an employer creates, you as the company, you create light duty positions for employees when they are occupationally injured if they are unable to perform one or more of their regular job duties. And we have an employee that can no longer perform functions of her position because of a disability caused by an off-the-job accident. She requests that an employer create a light duty position for her as a reasonable accommodation. Employer denies. Employee requests because she has not been injured. Employer denies the request because she was not injured on the job. Likely we've violated the ADA. However, the employer must provide another reasonable accommodation absent undue hardship if it is determined that the only effective accommodation is to restructure that position. Again, possibly redistributing the marginal functions of the position or restructuring the position. And, the employer's responsibility is to provide the reasonable accommodation unless it can prove that that's an undue hardship. This question in one form came in very recently, so let's see if we can make sense of this here in our quick closing. If an employer reserves light duty positions for employees with occupational injuries, does the ADA require it to consider reassigning an employee with a disability who is not occupationally injured to light duty positions as a reasonable accommodation? If that didn't make sense, don't worry, these webinars are recorded and you're welcome to revisit this and go through these notes once more, because I know we're moving very quickly here. I've had the benefit of reading the questions and everything ahead of time and creating answers. So you're all seeing this at first blush, and some of this may be a bit jumbled in your mind, so don't hesitate to revisit. The answer here is yes. If an employee with a disability who is not occupationally injured becomes unable to perform the essential functions of his or her job, and there's no effective accommodation available, the employer must reassign him to a vacant, reserved, light duty position as a reasonable accommodation if that person can perform its essential functions with or without a reasonable accommodation. So there, we have a reasonable accommodation, and then we have to, as a light duty position, and then we're also reevaluating, can this person perform this reasonably accommodated light duty position? Can the person perform the essential functions of it with or without a reasonable accommodation? So it's, we go down that inevitable black hole, and that their reassignment would not impose undue hardship. So this is because reassignment to a vacant position and appropriate, modification of an employer's policy are forms of reasonable accommodation required by the ADA. An employer cannot establish that the reassignment to a vacant, reserved light duty position imposes an undue hardship simply by showing that it would have no other vacant, light duty positions available. If another employee became injured on the job, that's not going to be an undue hardship, because I know some of you have those positions, those light duty positions available, and you say, well, yeah, but when John comes back, he's going to take that last one available, and that's going to be an undue hardship, right? Because we'll have no other vacant light duty positions available if he takes it. No, that argument's not going to work. For those of you that are noticing we're going over, I do apologize. I project about no more than 5 more minutes. So if you'd like to stay with us, you can. Here we have an example of an employer that has light duty positions, which is actually, I've taken this from one of you actually. Light duty positions, which it reserves for employees in its manufacturing department when they are unable to perform their regular job duties because of on-the-job injuries. We have an employee who's an assembly line worker, has multiple sclerosis, which substantially limits a number of major life activities. Eventually, the employee is unable to perform the essential functions of her position with or without reasonable accommodation because of the MS, her condition. As a reasonable accommodation, the employee requests that she be reassigned to a vacant light duty position for which she is qualified. Employer says that the vacant light duty position is reserved for employees who are injured on the job and refuses to reassign employee, although it would not impose an undue hardship to do so. So here's an example where we're, refusing. We think we have a legitimate reason for refusing the reassignment to the vacant light duty position because of, our reasoning. As on this hypothetical, it's because we're reserving it for people that got injured on the job versus people that just have a, a disability-related condition. But here we would have violated the ADA by refusing to reassign her to that vacant light duty position. So where we do have those vacant light duty positions available, and we want to argue that it's going to be an undue hardship to reassign somebody to that, that is covered under the ADA, I would say stop and reevaluate. If an employer has only temporary light duty positions, must it still provide a permanent light duty position for an employee? No, the ADA typically does not limit an employer's ability to establish or change the content, the nature, or functions of its positions. So For example, an employer is free to determine that a light duty position will be temporary rather than permanent, and that's relevant for some of you that have seasonal work, and some of that seasonal work can be light duty. So if an employer provides light duty positions only on a temporary basis, or say a seasonal basis, it need only provide a temporary light duty position for an employee with a disability-related occupational injury. And that's working on the presumption that the light duty is going to be the accommodation. Good. Okay. So, and that actually is the last thing that came in. So, if you have any other questions, please don't hesitate to reach out to me. Of course, I'm available to answer this and also give you access to this webinar if you need to revisit it. I'll see you next time.